The Administrative Procedure Act permits courts to review final decisions of administrative agencies. Although the standard of review is deferential, agencies must still provide evidence justifying their decision-making. In Safe Extensions Incorporated versus Federal Aviation Administration, the court examined a regulation on runway lights that was light on supporting evidence. The Federal Aviation Administration, or FAA, was authorized to create regulations for air safety. One such regulation it issued concerned runway lights. Lights sat in metal bases and had to retain their alignment to illuminate the runway properly, even after experiencing significant forces, such as from airplanes and snowplows. Because runways were frequently repaved, bases had to be adjustable so that their height remained even with the runway surface. Bases used two types of technology to achieve this goal. Adjustable bases had an extension piece threaded to the top of the base, which could be twisted to increase the height. Fixed bases had stacking, linked extensions on top. The FAA required both types of bases to pass a torque test, meaning that the base could withstand a strong force without rotating. For 35 years, the same test applied to both types of bases. In 2005, the FAA issued an advisory circular that kept the same test but required only adjustable bases to pass it. The FAA then issued another advisory circular, which imposed a more stringent torque test. Adjustable base manufacturers objected that the test was impossible to pass, and that fixed bases wouldn't be able to pass the test either if it were to apply to them. Nonetheless, the FAA issued a final version of the advisory circular imposing the same test. The circular stated that fixed bases had inherent anti-rotational features that adjustable bases lacked because they instead relied on a chemical bond, which had been known to fail in real-world conditions. Safe Extensions, a manufacturer of adjustable bases, sought review in the Circuit Court of Appeals for the District of Columbia, contending that the regulation was arbitrary and capricious.